I'm Ben Meiselas from the MeidasTouch network. There's an expression, you get the lawyers you deserve, and Donald Trump definitely deserves these lawyers in the Washington, D.C. federal criminal case against him being prosecuted by Special Counsel Jack Smith, which is set for trial in March of 2024. This latest legal brief filed by Donald Trump and Donald Trump's lawyers is perplexing, bizarre, odd. It's ranting and ravings for about 11 pages, I guess, to make Donald Trump feel good, and then essentially agreeing to the relief that Special Counsel Jack Smith is seeking, albeit requesting basically a month later than what Special Counsel Jack Smith is seeking. So would have just been easier probably just to pick up the phone and reach a compromise date. But no, the bluster and bravado and expressions of the prosecution cannot force President Trump to choose between the cross and the sword. Will it stay in the sheath? It's like, okay, what are you all talking about? What date do you want it to be? Let me break down what went down here. So Special Counsel Jack Smith is requesting and filed a motion to the court. A briefing schedule has been set. That's what this motion or opposition that Donald Trump's lawyers filed is all about. And Special Counsel Jack Smith is requesting that Donald Trump disclose by December 18th if Donald Trump will be relying on an advice of counsel defense at the March 2024 trial regarding Donald Trump's attempt to overthrow our free and fair elections in 2020. That's what the March 2024 trial is all about, because Donald Trump's lawyers and Donald Trump at speeches have given interviews and have made public statements stating or implying that Donald Trump's defense would be that he relied on the advice of lawyers who it's their fault. They're to blame, not Donald Trump. That's essentially Donald Trump's defense that he's put out there to the media. So Special Counsel Jack Smith said, well, if that is really what your defense is going to be, then that carries with it certain implications. And when you assert an advice of counsel defense at trial, that then waives attorney-client privilege. Because if you as a criminal defendant are blaming your attorney for your conduct and saying that's why you don't have the requisite mens rea or mental state to commit the crime because it's your lawyer's fault, you waive the attorney-client privilege between you and your lawyer, and you have to then establish that you provided your lawyer and your lawyer provided you with all of the relevant facts, and that notwithstanding all of those things, the lawyer was the one responsible for pressuring you to engage in illegal conduct, and that the lawyer had all of the relevant information. You have to establish that. So it waives attorney-client privilege. And Special Counsel Jack Smith, in his brief, explained that there are at least 25 witnesses, including a family member of Donald Trump, unclear who that is, we suspect it to be Jared Kushner, who have refused to provide documents or information or testimony on the grounds of attorney-client privilege. So if indeed Donald Trump's asserting advice of counsel as a defense to why he aided and abetted an insurrection, then Jack Smith's like, let's come up with a date where we know that that's what's going to be his defense so we can get our hands on these records and prepare appropriately for trial. Jack Smith says, let's do it on December 18th, which is a deadline relating to witnesses anyway. So December 18th is a good date to do it. Donald Trump spends 12 pages or so whining and complaining, this is unconstitutional, this is a witch hunt, don't use it as a sword and a cross all at the same time. So Donald Trump saying all that. But then when you really get to the crux of what Donald Trump is saying here, Donald Trump's lawyers are like, okay, well, we're cool with doing it at the jury instruction phase. So we'd be happy to turn it over around January 15th. So it's like, what? You spent all of this time when special counsel Jack Smith said December 18th, and you said January 15th. This is what it says on page 13. Nonetheless, Donald Trump, and they keep calling him president. Nonetheless, Donald Trump agrees to provide notice to the prosecution of whether he intends to pursue a formal advice of counsel defense at the time jury instructions are due, which is currently January 15, 2024. If at that time Trump requests an advice of counsel instruction, the court should solicit briefing to determine a reasonable schedule for Trump's production of relevant materials, depending on the scope of the requested instruction. And what Donald Trump's trying to do there also is he's trying to build in a way to try to delay this case and continue it from March to April or to May, because he's hoping that that will cause a briefing schedule, will cause delay. Then maybe depending on what the judge rules, Donald Trump can try to file an appeal and then seek a stay. By the way, we're doing another hot take on this, but in connection with the judge's limited gag order that limits Donald Trump from threatening the court, witnesses, and the special counsel's office, Donald Trump filed a request to stay the case pending a resolution of the gag order that was imposed by Judge Tanya Chutkan. Judge Chutkan's so brilliant because she saw right through it. And she's like, all right, I will on my own voluntarily stay the gag order while you go and argue to the Court of Appeals, the D.C. Circuit Court of Appeals, that you should be able to threaten us. I will pause the gag order. You will still be bound by the terms of your indictment release, but go whine to the D.C. Circuit, and you're not going to slow down the proceedings. It was a brilliant move by Judge Chutkan, but one of the things Donald Trump's trying to build in here is, well, let's do a briefing schedule after January 15th about what we're turning over, because then Donald Trump's going to want an emergency delay of trial. That's what he's setting up for right there. But this Trump response in opposition to prosecution's motion for formal pretrial notice of defendant's intent to rely on advice of counsel defense. This is what it says. It says, under the federal rules, defendant has no obligation outside certain inapplicable exceptions to provide his accusers with pretrial disclosures. Nonetheless, the prosecution requests that the court depart from ordinary order and invent an entirely new set of rules that would require Trump and not the prosecution to provide detailed description of core defense work product 2.5 months before trial. And Trump goes on to say, these demands place an unacceptable burden on Trump to foreshadow a possible formal defense. The prosecution's request demonstrates the constitutionally fatal unfairness of this entire proceeding. And then on and on and on. It's this is unfair. That is unfair. Nothing's going to be fair for Donald Trump. This is all a witch hunt against Donald Trump. The prosecution cannot force Trump to choose between the cross and the sword. And then Donald Trump finally says at the end, after, I'm reading this brief, you're going through it. And then it's like, okay, what do you ask? What are you trying to say, Donald Trump? Requiring early disclosure of a defense that involves reliance on counsel is inappropriate given important implications of that defense. Thus, until Trump decides to use privileged information to influence a decision maker, his attorney-client privilege should remain intact. Nonetheless, Trump agrees to provide notice to the prosecution of whether he intends to pursue a formal advice of counsel defense at the same time jury instructions are due, which is currently January 15, 2024. If at the time Trump requests an advice of counsel instruction, the court should solicit briefing. And then the conclusion. The prosecution's motion offends due process and undermines Trump's fundamental right to defend himself in a criminal prosecution. Accordingly, the court should deny the motion. However, Trump will agree to pretrial notice. And then this massive footnote. What are you doing? Like, what are you doing? I also want to just mention this as it relates to advice of counsel. The fact that Donald Trump's 2 lawyers have pled guilty in the Fulton County District Attorney case, that's going to be some smoking gun evidence against Donald Trump and Special Counsel Jack Smith's federal criminal prosecution in Washington, D.C. Jack Smith should give a big thank you to Fulton County District Attorney Fani Willis for her incredible work. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Let's get there in 2023. Check us out at patreon.com/MeidasTouch as well, and have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.